I was a strong supporter of the death penalty throughout my life, adult life, until recently. Last year, a major Texas newspaper established to my satisfaction that one of the prosecutions that I handled may have resulted in the execution of an innocent man. I believe prosecutors whose best efforts may have produced unfortunate results in capital murder cases have a moral duty to publicly acknowledge and accept responsibility for their mistakes. I fervently hope that there are only a few prosecutors and former prosecutors in America today who find themselves, as I do, in the position of having to admit an error in judgment that may have led to the execution of an innocent man. I'm here today to discuss the death penalty from the perspective of a former prosecutor who is responsible for the prosecution and execution of a man who may well have been innocent. And although it's crucial that we be willing and able to look back and correct the errors of the past, as Montana has done in the non-capital convictions of Chester Bauer, Jimmy Ray Bromgard, and Paul Cardinoe, it's even more important that we look to the future in the search for a system that guarantees the protection of the innocent. The state of Montana has taken an important step in that direction by creating the Office of the State Public Defender. And as important a step as that is, doing so will not guarantee the protection of the innocent in capital murder cases. As is the case in Texas, the criminal justice system in Montana, on its very best day, is driven by very dedicated but imperfect human beings. And as hard as we try to get it right, sometimes we just don't. Our courts and juries determine guilt or innocence based on testimony from witnesses who are sometimes wrong, witnesses who don't always tell the truth. And it's against this backdrop, what our states have in common, that I address the issue of innocence in the context of the case of Reuben Cantu, who was prosecuted by my office in 1985 and executed in 1993. Because Reuben Cantu didn't receive just a fair trial, but arguably received a perfect trial, the facts of his case are both instructive and haunting for every state that permits the death penalty. Reuben Cantu had a fine defense lawyer. He had an ethical prosecutor. He had a fair judge, and he had a jury that returned the only possible verdict based on the evidence that was presented. And yet it's been determined 21 years later that he may well have been innocent. Whether he was or not, the system failed him. I made an error in judgment by permitting Cantu to be prosecuted for capital murder based on the uncorroborated testimony of a single eyewitness. Most prosecutors in America, confronted with the same circumstances at that time, would have made the same decision that I made. That eyewitness, who had absolutely nothing to gain but trouble for doing so, has now recanted his sworn testimony under circumstances that make his current claim very credible. One might argue that my mistake can be remedied by simply requiring more than the testimony of a single eyewitness in death penalty cases, and that would be a good decision. But it would ignore the fact that prosecutors acting entirely in good faith make all sorts of judgments in murder cases, and because they are human, sometimes make mistakes. Add to that the undeniable fact, the reality that judges, jurors, defense attorneys, and witnesses also make mistakes, and what you end up with is a system that by definition cannot be relied upon to protect the innocent in all cases. The system that we rely on to decide who may live and who must die is broken. And because it is driven by human beings, it can't be fixed. What we've seen over and over in this country are situations in which witnesses who have nothing to gain but trouble by recanting sworn testimony nevertheless do so, and for good reasons. We've seen junk science debunked, the exposure of terrible mistakes, by forensic laboratories. And finally, we've seen misconduct and errors by many players within the system. In short, the undeniable fact is that the system we rely on in this country to prosecute capital crimes simply can't be trusted to protect the innocent. Some suggest that it's good enough if we get it right most of the time in capital murder cases. The good intentions and strong procedural safeguards like you have here in Montana may be sufficient in most cases, but if you believe, as I do, that we must always get it right in capital murder cases, that the system must always do what is intended, which is to guarantee the protection of the innocent, I submit to you that accepting a system that tries hard and gets it right most of the time is simply not good enough when the sanction is so final.